meeting is being recorded.
Oh, I want to make sure you know that. Well, good morning, everybody. My name is Debbie Goldman, and I am the assistant to Katrina at Naturally Austin. I also assist the Naturally Network, the nationwide nonprofit. I'm really happy to be here. Katrina is taking a well-deserved few days before we launch into this busy Earth Week, which we hope you will all join us. This morning, we have, sorry, I'm trying to juggle the waiting room and a little intro here. So this morning we have Stephen Aguilar with us from Michael Best. And Stephen is a senior counsel at Michael Best, which is a law firm that has spread across the country with nearly 300 attorneys, 19 offices across the US. Stephen is based in their San Antonio office. By the way, I am coming to you live from Seattle, Washington, so it's quite early for me. But it's nice to be with you all. Pretend like I'm in Austin and San Antonio. Stephen helps entrepreneurs launch and grow their companies, from planning at the earliest stages to funding to growth and scale up. He provides practical advice along every step of the way, counseling clients on key transactional and business matters, including entity formation, corporate governance, private equity, and venture capital investments, contracts and agreements, brand protection, acquisitions and divestitures, employment issues, including immigration, and when needed, dispute resolution. He represents clients from a diverse array of industries, including technology, consumer products, manufacturing, energy, and media. Stephen was one of our mentors on our last MO fellowship, and we're really excited to have him back with us today, launching your first virtual class. Stephen, I'm going to hand it over to you, and I'll keep letting people in. If you have questions, please put it in the chat. Stephen's going to be giving a presentation, and I'll continually check the chat, and we'll pepper the questions in, and then we'll also have time for Q&A at the end. Over to you, Stephen.
Great. Thank you, Debbie. Appreciate the introduction, and good morning, everyone. It's great to be with you this morning, and an honor to be one of your first virtual classes. It's great to see everyone. Today is going to be a Legal 101 class, and it's called Recipe for Avoiding Disaster, or Legal 101. And I know we all may be coming kind of from different backgrounds, different exposure to some of the concepts that I'm going to be addressing today. Some of them you may be familiar with, some of it may be new, but hopefully it'll be at least a good refresher for some of y'all that may have already kind of seen some of these ideas before. But if there's any questions or comments that you have kind of along the way, please feel free to drop those into the chat. And Debbie has graciously offered to interject with those comments and questions, and I'll answer them as we go through. And she's also going to be helping me navigate the presentation. So thank you for that, Debbie. So, just a disclaimer, of course, this is not going to be specific legal advice, but just kind of an overall presentation about some of the things that you're going to want to be aware of as you get your company started and growing and move down the road to, trying to get investors involved and on your way to a successful and profitable venture. Apologies up front. The theme you're going to see is going to be food related. So if you haven't had breakfast, or if you're already ready for lunch, apologies for some of the food references that you're going to kind of see throughout the way. But I thought it was just kind of a fun way to approach some of these legal concepts that we're going to be talking about here. So again, we're going to be addressing just some of the key legal mistakes that new startups often make, the things that me and my colleagues often see in our practice, and some of the best practices going forward from years of working with startups and mid-level emerging companies over the years. So each section we're going to talk about a particular key legal issue, and really telling you kind of what documents that you're going to want to begin addressing and collecting and organizing in a folder, on your computer, so that when it comes time down the road for you to bring on investors and to finance the company, kind of have everything arranged and organized in a way that these investors can review and be comfortable with kind of where the company is at. So Debbie, we'll go ahead and go to the first slide.
All right, are you guys seeing the strip of participants as well? Having trouble here. Hang on just a sec. There we go.
So these are the main things we're going to be talking about today. Entity types for what type of entity you're going to be selecting, or if you already have an entity, what other alternatives may be out there for you, kind of what works with each type of entity, what may not work. Founder equity splits. How do we divide up the equity in a company? Vesting, what is that in terms of how equity is earned over time by the founders of a company. Intellectual property, that might be one of the most important things related to your company is protecting the intellectual property, the ideas, the assets of your company that essentially might be the backbone of your company aside from the human capital. Accredited investors, that's an important concept when it comes to raising money. Who can you legally try to sell equity in your company or try to raise money from? And then finally, I just touched on the due diligence folder, the documents that we're going to want to keep over the life of the company organized so that when you have an opportunity to bring on an investor, you're able to kind of show them where the company is at, where it's been, and give them comfort that they are investing in a solid company. Okay, next slide, please. Alphabet soup, help. So you'll begin to see as you kind of begin, delving into your business and into the legal side of things with your business and your organization and dealing with the various governmental entities that you're going to have to become acquainted with over the next months and years over the life of your company. And there's just a lot of different types of acronyms out there for different types of entities, different types of forms, and what do these all actually mean? So when you first start a company, first thing you're going to want to do, of course, is to form a legal entity. And that has a number of benefits for you. Some of the primary ones are liability protection. If you are out there kind of operating without a formal entity in place, then you risk exposure to your personal assets. If there was ever a claim made against you and you're not protected either in an LLC or a corporation, then theoretically you could have your personal assets there at risk, and that's obviously not something that you want. So getting a formal entity in place is definitely important. Again, there's a lot of different abbreviations thrown around. What do those mean? What's an LLC? What's a C Corp? What's an S Corp? There's even B Corps if you've not heard of those. And that alphabet soup of acronyms can oftentimes get very confusing. And so we just want to make sure that we choose the right type of entity for your company. Then we can go to the next slide, please.
Yeah.
Okay, so the most two common types of entities are LLCs, which are limited liability companies, and C corporations. And where do we form those? Well, there's pros and cons to either type of entity. The pros for an LLC is that they're relatively cheap and easy to set up. If you're setting up a Texas LLC, you can do that online. It costs about $300 to do that. And it's an online form. Really, all you need to do is identify who the managers of the company are going to be, whether that's going to be the members themselves, or whether you're going to have maybe outside people also be involved in the management of the company. You need to make sure you have a registered agent identified. A registered agent is a person or a professional company that is responsible for receiving legal notices on behalf of the company. So that can be you initially, or you can pay a company, about $150 a year to take that burden off you. And then any sort of legal notices get sent to them, and they provide those to you. You need to identify, the purpose of the company. But that's essentially it. It's about a 5-screen application online, very easy to do. And voila, at the end, you have an LLC. And again, that'll give you that liability protection. That's very important as you start getting off the ground and start engaging with other parties to have that in place. One of the other benefits that LLCs offer is a taxation benefit. LLCs have what's called pass-through taxation. And that means that you're only taxed one time at the individual owner level. Owners of the LLC are called members. So you're only taxed one time at the member level on any sort of distribution or income that is made. So it's got that tax benefit there as well. Some of the cons of an LLC are that sometimes it can be a little bit complicated if you're trying to raise money. And that's because a lot of venture capital firms or investors are more comfortable with C corporations. And those have been around longer. LLCs comparatively are kind of a relatively new entity type. And so there's just not quite as much history there in terms of case law and court decisions and familiarity in that sense with LLCs. But that's not to say that some investors would not invest in LLC. There are many, and I've seen many, and we've worked with many who are comfortable investing in LLCs. It's just C corps are sometimes a lot more typical. A lot of venture capital firms actually are prohibited from making investments in their own organizational documents. That's just one thing to keep in mind with an LLC. You can always convert down the road from an LLC to a corporation. That's not difficult at all. Just involves some filings with the state to convert and change from being a member in an LLC to a shareholder in a corporation, or a manager in an LLC to a director in a corporation. So that's definitely doable if you all decide you want to start out as an LLC. In fact, we typically advise, LLCs initially if you're not sure whether you're going to be raising equity right away or doing a financing right away. That's because LLCs do offer a lot of flexibility that a C corporation may not. It's a very popular form, LLCs are, with startup companies, because it doesn't have a lot of the corporate formalities in terms of having regular board meetings, providing certain notices to shareholders and directors. The statutes usually don't provide as much flexibility as they do with an LLC, where you can kind of typically do whatever you want with an LLC in terms of kind of providing notice or conducting meetings and things of that nature. So that's why it's very popular with startup companies. Now with C corps, they are a little bit more expensive to kind of initially set up because of those formalities I was talking about. There's a little bit more documentation that may be required initially when you're setting up a C corp. So there is kind of an initial upfront cost, but that may be worth it if later on down the road you decide you want to convert from an LLC to a corporation later, and now you're paying those additional expenses. So that's just one thing to kind of keep in mind when you're deciding what type of entity to choose. And as I touched on, investors are typically more comfortable with C corporations just because of the history that's there with those. So if you do know that you're going to be raising equity and doing fundraising later, then maybe it makes sense kind of right off the bat to form as a C corporation. I mentioned S corp earlier, and just to shed a little bit of light on that in case you've seen that around. An S corporation isn't exactly a distinct type of corporation. It's really an election that's made with the IRS to be treated as a small corporation. And you get some additional tax benefits if you comply with certain requirements that the IRS has. So when you hear the word S corporation, it's not like you're filing as an S corporation with the state. You're still going to be a regular corporation, but you are electing with the IRS to be treated as an S corp and get the tax benefits that would provide you as long as you meet the requirements, which typically involves having a limited number of shareholders, shareholders that are not entities, so only individuals typically, and U.S. nationals only. So if you meet those requirements, and you can make that election with the IRS and maybe get a little bit of tax savings there. We have Delaware. You're going to see a lot of times, where do I form my company? Do I do it in Texas? Do I do it in Nevada? Do I do it in Delaware? And a lot of the advice you may get is to form in Delaware. And again, that's because Delaware is the state that has the most history of dealing with corporate law. They have a whole court system dedicated to just dealing with business issues and corporate law issues. So it's a jurisdiction that that investors are very comfortable with. And so they may require you to be a Delaware corporation before they invest in you. That's not always the case. Again, there's always exceptions to rules and in everything. And this is one of those things that I've worked with plenty of Texas corporations that have had plenty of successed investment opportunities. So it just kind of depends on who you may end up working with and partnering with in the future. But I'd say as a default, Delaware is kind of where most investors and most companies kind of end up organizing themselves. And you can always convert or change jurisdictions from Texas to Delaware later in the future. That's something that's relatively easy to do as well, but of course involves some costs at that time. So it's just one of those cost benefit analysis that you need to do kind of upfront on where you want to do that. So what do you keep in your due diligence folder kind of based on this? Well, you're going to want to keep your organizational documents, whatever you filed with the state to form your entity. If it's an LLC, that might be your certificate of formation or your articles of organization. If it's a corporation, it might be your articles of incorporation. So that's what you want to keep. I see a question here. Would you need a Delaware address when transferring? No, you don't. You can have your principal office in Texas, but you do need a registered agent in Delaware or whatever state you end up registering in. That is a typical state requirement, is that you have a registered agent in whatever state you are registered in. So you can have your place of business in Austin, be organized in Delaware, and have a registered agent in Delaware. And that's, the state wants to make sure that, if someone has a claim against a company, that person can find someone to serve legal notices on. So again, you can, we usually hook up our clients with a registered agent, a professional registered agent company that charges about $150 a year to provide that service. Registered Agent Solutions is one, Cogency is another one. But you identify them in your formation documents and you pay them your annual fees, and they take care of that for you. So that's really the only presence that you would need to have in Delaware or whatever state you end up registering in. Okay, let's go on to the next slide, please, Debbie. All right, so now that you're organized, what's next? Dividing up that yummy pie. How are we going to divide up the equity or the ownership in this company? That's a challenging question, right? It's a difficult question. It's a hard question, and sometimes a hard conversation to have if you haven't already broached that subject with your co-founders. But it's an important one, obviously, and one that you need to have early. And I'm just going to address this question I see popping up here now before I get too much deeper. But can you please explain a little bit about a holding company. Yeah, so holding companies, typically are used as maybe an investment vehicle for the founders and investors to own their stakes of the company, and those companies end up holding what would be maybe the operating company. And so if you kind of picture like an organizational chart, at the top you have the holding company that's owned maybe 80% by the co-founders, 20% by the investors, and then underneath that you have a subsidiary that would be the operating company, and that's 100% owned by the holding company. It's holding that company, or holding all the shares or all the equity of that company. And so, most of the business and the operations are then run out of that subsidiary operating company. And that's a way to kind of get a little bit of layering between the investors and the operating company, and provide some protection, additional protection to investors and founders, so that if there's any sort of claims or liabilities of the operating company, the one that's actually out there doing business, there is kind of that protection between that and the holding company. So I hope that answered your question, but if not, shoot me a follow-up here. Again, having that discussion earlier with their co-founders on how are we going to divide this up? We all may be best friends now. We may, think we're never going to have any sort of disagreements about this, but you need to have those conversations early. And what happens if something goes wrong and someone bails on the company? What are we going to do in those situations? And those things are usually addressed in the governing documents of the company, which we'll address kind of throughout the rest of the presentation, in terms of vesting, in terms of what you have in your operating agreement or your company agreement if you're an LLC, or your founders agreement if you're a corporation. And so we want to focus, kind of on building processes in those documents for problem solving. We don't want to have to be too formalistic, making rules about, this is what we're going to do in this situation. This is what we're going to do in this situation, because inevitably you're going to forget something or not account for something. And so it's more about kind of just building in a process. How are we going to handle a disagreement when we're confronted with that? So whatever arrangement you come up with, that's going to be, again, reflected in your founders agreement or your LLC company agreement, and that's going to go in your due diligence folder. All right, next slide, please, Debbie. There's no magic formula, unfortunately, and it just really comes down to a negotiation, a conversation on kind of what is being brought to the table, and what everyone kind of live with. And so you want people to be incentivized based on their equity. And as long as people are incentivized to keep working and keep doing good for the company, then you're going to be in good shape. Now, is there anything wrong with people having equal shares? There may be stories out there that, investors don't like that because that's going to lead to deadlock. But that's okay to have equal or equal-ish shares. What the investors are really concerned about is that there is just kind of something in place if there's a stalemate, if there's any sort of disagreement or a deadlock. And, I've worked on company agreements where it's as simple as a coin flip. It can be as easy as that. If we can't reach an agreement, we're going to flip a coin, and that's what it's going to be. You may not want to leave it to chance. You can have other mechanisms put in place. We'll go to an independent third party that we all agree on, that we trust, that is, going to be a good sounding board for our company. And that's who we're going to rely on if we can't make a decision. So as long as you have something in place, that's really what's most important. Some decisions may require what we call a supermajority decision. So not just a simple 51% or 50.5%. Some decisions are major decisions or fundamental decisions of the company. Are we going to bring in a new member to the company? Are we going to issue equity to this person? Are we going to terminate the company? Those might require 65% or 75% of the people who are entitled to vote to make that decision. So, those are again conversations to have about what are we going to consider the major decisions that we need super majority or more than just a majority of the people to decide to move forward with. So again, it's just really about incentivizing future work. We don't necessarily want to be rewarding always just the past contributions. It's about what are we going to be doing in the future here. Can't give someone 90% of the company just for coming up with an idea. This is about execution, right? Not the ideas. So we need to make sure that people are incentivized to do good work and to keep contributing as the company moves forward. Next slide, please, Debbie. Okay, so still on the topic of founder equity, we need to remember that the equity in your company is going to always add up to 100%. So on the left side, we've got a small pizza representing kind of where the company is at an early stage when it's raising what we might call a seed round, a seed investment. Okay, so maybe from some early investors in the company. Right now that pie is small, right? Because we're early, we don't have a lot of operational history, we don't have a lot of maybe revenue going, and so it's a smaller pie, but it's divided up equally between maybe 3 of the founders and an investor, and we all have equal shares here. When you raise future rounds of financing, the slice that each of the current investors and the founders get smaller, and that's called dilution. But the good thing is the pie and the equity gets more valuable. So when we look at a Series A after the company's been operational for a while, been growing, been getting some good history underway, you got a bigger pie. And so even though everyone's proportional slice is a little bit smaller, that slice is bigger and it's worth more. So even though you're going to get diluted a little bit, in the end, it's a good thing because your slice is going to be worth a little bit more. So the point is we want to focus on growing the company. Don't obsess over being diluted. That's going to happen. And, in the end, that's going to be a good thing. We've never heard successful founders really complain about dilution, but we've seen a lot of companies fail from being underfunded and being too overly concerned with being diluted. So that's just something to keep in mind. When you do raise money, the legal documents that you're going to be keeping in this due diligence folder are going to be a stock purchase agreement, stockholders or shareholders agreements, and there's several other types of agreements that kind of when you get to the seed round, the Series A, that you're going to want to keep in your folder as well. An investors' rights agreement, which may provide for what are called preemptive rights, and that's the rights for certain shareholders in the company to be able to buy future equity in the company in order to try to maybe maintain their percentage in the company. They don't want to be diluted, so they say, all right, well, if you're going to go sell shares in the future, we want at least the option and the opportunity to buy some of those shares so that we're not diluted by new investors coming in. It may have, the investors' rights agreement may have rights to access to information, rights to require their approval before the company takes any certain types of actions. They've made the investment in the company and taken on that risk, so they want to be able to have to give approval before the company makes certain decisions. Those agreements may also include a voting agreement, and that includes requiring shareholders to vote certain ways for directors. Okay, the investors want to make sure that their representative is on the board of directors so that they have a say in the governance of the company. So those voting agreements make sure that shareholders are obligated to vote in those ways. And you have rights of first refusal, which says that if certain shareholders, contemplate transferring or selling their shares to someone else, that the company first and then the investors get an opportunity to purchase those shares first. And so that's a means of kind of keeping other unknown shareholders out of the company, and to make sure that the investors have an opportunity to purchase that equity and maybe grow their stake in the company. So all these are the kind of documents that are, of course, going to be kept in your diligence folder. If you want to get a little bit of a flavor for what these look like, can be somewhat dense, but maybe good exposure to kind of what some of these concepts may look like in practice. You can go to seriesc.com, I believe is the website, and they kind of have some form documents on there on what a stock purchase agreement might look like, and what some of the investment agreements might look like. For a Series A, you can go to the National Venture Association, and they have their form documents there as well, to get a sense of what those look like. So just another thing that I want to quickly mention while we're kind of on the topic of fundraising is just the types of fundraising. A lot of early stage companies may not proceed directly to selling shares in their company. And that's because when you're selling equity in the company, you have to come up with a valuation. What is my company worth? And it has to be agreed upon by the investor. We think your company is worth $5 million or $10 million. And a lot of times when the company is in its very early stages, that's hard to determine. There's just not a lot of history there. There's not a lot of revenue there to make that determination. So rather than selling shares of the company at a certain valuation, a lot of companies do what's called debt financing, which is raising money through the sale of debt, basically through promissory notes, so loans, or convertible loans called convertible notes. And what that means is that an investor will purchase a convertible note for $100,000. And then later on down the road, when the company is ready to sell shares of the company at a certain valuation, those early investors have those convertible notes convert into shares at that time. And it's usually kind of at a discount than what the later investors are buying those shares at. So that's the incentive for those early investors to kind of get on board and purchase those convertible notes, is that they're going to be getting a deal later on down the road on the sale of those shares. And so you don't need a valuation when you come up with a convertible note. That's a can you kick down the road for later. So that's just something to keep in mind when it comes time to raising money, that you may want to consider debt financing through a convertible note, through a SAFE agreement, which is kind of a similar concept. But I just want to kind of mention those. I had a couple questions. I missed the first one. Do you have an opinion on when a startup should issue a convertible note versus a SAFE? So, I mean, they're both good. I think SAFEs, are becoming more popular right now because for a couple of reasons. On the company side, the nice thing is, whereas a convertible note is like a promissory note or a loan, in that it has a maturity date, meaning you have to pay that back according to the terms of the note in maybe 2 years. So the maturity date's going to be in 2024. You have to pay that money back if it hasn't already converted into shares at that time. Whereas a SAFE doesn't have that obligation, doesn't have that maturity date. So if you're able to get away with raising money through a SAFE, that is probably a better pre-money or post-money SAFE, which one is better for a small company. I think I guess it depends on the valuation, but I'd probably go with a pre-money SAFE on that, or actually, change my mind, a post-money SAFE. That way you can kind of determine this is what the valuation is going to be. And if we don't, end up raising that, whatever the amount of money that we think we're going to raise is, you're kind of already locked into what that post-money valuation is going to be. So I think post-money is probably where I'd go for friends and family around. So, same answer, post money there, I'd say. friends and family, something we'll touch on here in a little bit, but I'm going to go with post money for that reason, that you can kind of lock in that valuation later, and it may, be independent of whatever amount you end up raising later. All right, next slide, please, Debbie.
There's one question here about repeating what is.
Yes, thank you. I missed one. What was the question?
Oh, repeating what a SAFE is.
Yes, so a SAFE agreement is a simple agreement for future equity, and it does operate similarly to a convertible note in that, the investor is providing money now to the company in the event that later it does convert over into shares or equity in the company, but it does have the benefits of a convertible note, that you don't have to come up with a valuation right now as you would with a priced equity round, and it doesn't have the maturity date that a convertible note would have. So you're not, if you end up pushing up against that maturity date on a convertible note, you don't have to worry about paying it back or negotiating with the investor to try to extend that maturity date. So it's got that benefit to it. And if you want to see that, the safes are available online. It was developed by Y Combinator. And, the nice thing is that whereas convertible notes can be negotiated and, one can look different from the next, safes typically are standard across the board. For that reason, they are, developed by Y Combinator, and generally one safe will look the same as the other. So there is that consistency across the board. So that's another nice feature of that. And yeah, we got a link there to the documents to take a look at. All right, so start the egg timer. We touched on what happens when you and your co-founders divide up your equity. You've reached an agreement on that, but maybe there's a disagreement. There's something that happens that causes one of the founders to walk away. Now they're walking away potentially with 20-30% of the company. That's obviously not something we want to have. How do we protect the other co-founders in the company from that sort of situation? And so that's done with vesting. And vesting is the process through which over time you earn the equity, which has been set aside for you. And so we'll touch on that in the next slide. But what that does is prevent someone again from getting 25-30% of the company and leaving the next day. That'd be a horrible situation. You have to keep working for the company and contributing to the company in order to earn your ownership stake. So when you start trying to get outside capital for the company, we can almost guarantee that the investors are going to require that there's some sort of vesting in arrangement in place. The same way as co-founders, they want that assurance that the co-founders are going to be committed to the company, that they're going to have to stay with the company and keep contributing to it in order to earn their equity with the company. So, many times we may recommend that you put that vesting in place kind of earlier on, and that might be for a couple of reasons. One is, to ensure that everyone is, pulling their weight and putting in the work to continue to grow and develop the company. And that if you have that egg timer in place, that you may be able to keep that equity now that you've banked, rather than have to kind of start over with the next round of financing. If you're able to kind of negotiate that with the investor, you say, hey, we've already got the vesting in place. There's no need to have us reset or start that back over. We've already done that. We've had the foresight to put the vesting into place. So let's just keep things as is. Okay, next slide, please. So can we put vesting periods in retroactively if our governing documents aren't formal? Is a question that we just received, and yes, you can. That is definitely something you can do. You would just put in the vesting schedule that your vesting start date would be at some point in the past, and that whatever the vesting schedule that is agreed upon would be. What we have on the screen here is kind of what a typical vesting schedule that we would see with an early stage company. And the way this works is it's a 4-year vesting schedule with what they call a 1-year cliff. And what that means is, let's say you were issued your 20% of the company today. The vesting start date is April 7th, 2022. It has a 1-year cliff and it's going to vest over 4 years. What that means is, and this could be done a certain way, but 25% say would vest in 1 year from today, April 7th, 2023. You earn that first large tranche of equity, that 25% of whatever your particular stake is in the company would be earned on the 1-year anniversary of today. The rest of it then would be split up equally over the following 3 years in perhaps equal monthly installments or quarterly installments, so that for each month or quarter that you continue to remain in service to the company, either as an employee or as a director or an officer of the company, you're continuing to earn that equity over time. So if someone leaves the company, say in 2 years' time, then what happens is, they've earned, half of whatever equity had been allocated to them, and they end up forfeiting the rest. If you're no longer in service with the company, you forfeit whatever you haven't earned because it's time-based. And so if you're not providing service to the company, then that's forfeited. Alternatively, if you're there at the end of 4 years, you've earned all of that equity. And so just kind of a legal side note, technically you own all of that equity that you were issued up front. But the distinction is that the company has the right to kind of take back whatever has not been vested from you. And so you lose that amount of equity. But, for voting purposes and things like that, you are technically still treated as the owner of that equity and able to vote the full amount of those shares. It's just that if you leave after, before it all vests, well, the company gets whatever is unvested back. There's sometimes some mechanisms built in place even for the company to repurchase vested equity, but that's usually at the fair market value of that equity, so that at least the person is getting paid whatever that equity is worth at that time. So you can kind of see why that egg timer is important. If you've been already kind of banking that equity for 2 years before you raise money, then you only have 2 years left before you own it all. That doesn't always work. Investors may say, listen, yeah, we understand what you were trying to do, but we're making a substantial investment in this company, and we need to know that you're committed to it for some certain time in the future. So we want you to reset or start over your vesting, and that's a negotiation and a conversation that you have to have with the investors. But perhaps at least if you've kind of got something in place now, you may be able to kind of meet halfway with the investor and be able to at least kind of keep or bank some of that equity. But, if you have to argue too hard about that, then you have to ask yourself, how committed am I to the company? So where are these vesting arrangements typically memorialized? It's going to be, again, in your founders agreements, your LLC company agreements. If you have a option plan or what's called a stock incentive plan, it may be in that or in the option grants, and the vesting schedules, all of which you're going to have to keep in your due diligence folder. So make sure you keep that organized. Next slide, please. All right, intellectual property. You've got the secret sauces to your company, what's going to really make it attractive and valuable to investors, besides, of course, the people involved in the company, is going to be, the intellectual property. That's a hot buzzword when it comes to startups and how to go about protecting that. And so there's going to be four main types of intellectual property or IP that you're going to confront when you, that you're going to encounter when you start your company. And those are listed there as copyright, trademarks, trade secrets, and patents. You know, and here we got maybe a representation of what a few of those might be with the Big Mac, but kind of just to touch on what each of those mean. You know, we have food and beverage recipes. How can we protect that? That's a good question. That's typically going to be with trade secrets. You know, unfortunately, like recipes are not copyrightable or trademarkable or patentable. I believe there is, you know, already significant case law out there that says, you know, a recipe is really a trade secret. And, you know, we'll touch on that here in just a moment on exactly how to protect that. Yeah, it's not really considered a copyright because a copyright is anything that can be written down, recorded, or drawn, but it's also an artistic expression. You know, someone can go out and replicate a recipe and, you know, it's not really an artistic expression. So, you know, copyrights are talking about songs and films and photographs and books and things of that nature. And of particular relevance to startup companies, it's software code. And so it doesn't protect the underlying idea, but just the expression of that idea. So that's why it doesn't really apply to a recipe per se. You know, it doesn't, you know, protect the underlying, you know, concoction, for lack of a better word, that you create when you have a recipe. It's just the expression of that idea. We have trademarks, and trademarks are important. That's, you know, typically what I see the most of with kind of these my early stage companies. And that's anything that would protect a product or service and that connects that product or service to the source of that product or service. And so that would typically be things like brand names or logos, product names, and can even be packaging or colors like the UPS brown or the FedEx purple and orange. Could be trade address, which is kind of a like a Taco Cabana. When you go in, you know, they have their look, you know, they have what their font and their colors and everything, just kind of their look and their appearance is trade dress, and that's protectable by trademark. And I missed a series of questions there, Debbie, if you can maybe help me kind of go through those. Let me see, open up the chat here. Okay, I think I got them here. Sorry, Debbie, I've looked into Form 901 via state of Texas to apply for a trademark, but how do you get a trademark applies to the whole US? Yeah, it's a great question. So typically, you know, we'd say probably forego the state application and go for the federal application, which is applied through the US Patent and Trademark Office, or USPTO. So if you go to uspto.gov, you know, they have their whole section dedicated to trademarks, and you can file that trademark application online. In fact, I think they may require you to do that now unless you can't access a computer, but you know, that's an application that's done online, and it's typically about a 6-month process to get that approved. And a lot of that is because it doesn't even get assigned. Your application doesn't even get assigned to a trademark examiner until 3 months after you file. Once it's assigned to a trademark examiner, they review the application. And, you know, one of the important things that they do that you need to do and that your attorney needs to help you do before you even file for the trademark is to do a search and make sure that you have freedom to operate with that mark, because that's what the examiner is going to do. They're going to look at the registrations in the trademark database, and if there's anything that they consider to be similar or to cause a likelihood of confusion in the public, they are not going to allow you to register that trademark. They're going to say, we already have an existing trademark on file that is similar to yours in connection with the same good or service. And that's another important concept there to kind of understand about trademarks is that when you file the application, you're going to be filing that mark in connection with a particular good or service in a particular category. So you can have identical trademarks existing out there, but as long as they're kind of existing in different worlds and different spaces with different goods and services, they can coexist, and the trademark office will allow those. But if there's any sort of overlap, even tangentially, then you might run into problems with the examiner saying, no, we can't allow this. But assuming there aren't any problems with the trademark applications, it's not a generic mark or too descriptive of whatever your product or service is, and then it proceeds to a publication period where the public at large has 30 days to oppose the trademark. And if no one files any formal opposition, then it'll move to a final registration. But that whole process, assuming it goes smoothly, takes about 6 months. And again, just to answer that question in a long-winded way, you apply for that trademark through the U.S. Patent and Trademark Office, and that's done through an online application. Do you recommend applying for a trademark for the name to start with, given if your logo isn't final yet? That's not a straightforward answer, unfortunately. I probably wouldn't, just because I wouldn't go through the time, effort, and expense of putting in an application, and then you end up changing your logo and having to go through that process again. Now, there may be some protection ultimately if you're not making a lot of changes to the logo. There is kind of some room for a protected mark to exclude marks that kind of look similarly to your registered mark. So, you might get a little bit of protection even if it's not the exact same, but I wouldn't typically count on that. I would probably wait until your logo is final before registering it. The nice thing is that, when you file a trademark, you either have to file it showing that it's in use, meaning I'm using this mark in connection and in commerce with my product or service. And here is a specimen example of me using it in that way. So you have to file it that way, or you can say, I intend to use it in that way. And I don't have a specimen at this time showing it in use, but I intend to use it. And you can continue to file your application that way, and then provide that specimen kind of at the end of the process. So even though you're not using your mark right now yet in connection with the sale of your product or service, you can go ahead and at least get your mark in line right now. So that way you can exclude anyone who might try to file a similar mark later on down the road, and prevent them from filing a confusing mark. Next question is, one of the main concerns is training potential employees and them misusing the knowledge of our inner workings after they leave the company or even while employed. Yeah, so that might be addressed by having employees or contractors or just other people associated with other consultants or advisors with the company, signing certain agreements that would prevent them from disclosing confidential or proprietary information, or depending on whatever their status is with the company. Typically employees are the only ones that can really kind of be prohibited maybe from competing with the company or disparaging the company later, or trying to take customers from the company. But yeah, definitely those are all considerations that you need to kind of have up front, and agreements in place with whoever is going to be providing services to the company to make sure that they're not misusing information of the company.
Even quick note on that. So sorry, on the employee subject, are there any templates or anything that we can refer to, or what would be the best way to achieve those type of contract, either designed specifically for us, or if there are some templates out there that we can start reviewing and putting them together.
Yeah. I don't know any specific templates out there. I mean, a Google search will turn up all sorts of, documents that you find online, either ones that you can kind of purchase off the shelf, or ones that, have previously been used in the past and are just kind of published online. But a lot of times those are incomplete or maybe bespoke to whatever arrangement it's pertaining to. So unfortunately, I can't point you to a specific one. And like I mentioned, before, a lot of it does vary depending on what exactly is the nature of this person's relationship to the company. Are they an employee? If they are an employee, then yeah, the company has a lot more leeway in terms of kind of restrictions on that person, in terms of what they can do while with the company and after they leave the company. If they are more of just a contractor with the company, so not an employee, but just an independent contractor providing certain discrete services, and you don't really have control over kind of who else they work for, then the company is much more limited in what they can prohibit or prevent that person from doing while providing services before or after to the company. Same with consultants and advisors. Those are typically contractor type of relationships. So it kind of really just depends on the nature of the relationship. Apologize for plugging, attorneys, but that's probably a situation where you at least want to go talk to an attorney and kind of give them a sense of what you're trying to do and what you're trying to accomplish, and then have them put something in place. But yeah, sorry, I can't point to anything online, but there are samples kind of available out there of what to look for, and we'd be happy to help you look at that, or we'd more likely kind of just develop something for you. Typically, trademark attorneys' fees is how much? Well, I know the filing fees are probably about $250 to $300 per trademark per class. So if you have a trademark that you're going to be filing and you're going to be making an application in connection with kind of several different classes of products and services, then that filing fee is going to apply to each different class. I have to double check what our attorney's fees are for that. I apologize, I just don't know that off the bat, but I do know that a lot of our intellectual property work is done on a flat fee basis, which is nice for our clients, because there is some predictability kind of on what you're going to be paying for that. So, and I know ours are pretty reasonable, because we have a very efficient and experienced trademark attorney who can get those on file for you pretty quickly. So yeah, our attorney's fees are pretty reasonable in that. Patents is another type of intellectual property, and that's really for inventions, and it gives a company the right to exclude someone from using their that invention. And there's several different types of patents: utility patents, design patents, and obviously that kind of goes beyond the scope of our conversation today, but that might protect inventions that the company has. And then finally, we touched on trade secrets a little bit earlier, and that's the fourth type of IP. And that's basically anything that the company wants to, that has value that the company wants to protect, and that it takes, explicit measures to protect and keep secret. And that would be formulas and processes and recipes and methods for doing things. And so the way that you protect that are through confidentiality, non-disclosure agreements, and kind of internal security methods. And as long as you kind of have all those mechanisms in place, then the trade secret is usually afforded that trade secret protection. And that would be things like the secret sauce here we have on the Big Mac, Coca-Cola, things of that nature would constitute trade secrets. All right, next slide, please. And just to address a couple of other questions I see that came up here, it says, can you file a trademark without a trademark attorney, and is it complicated? I would say that if you're not familiar with the process, then yes, it probably can be a little overwhelming, depending on how much time you want to devote to kind of familiarizing yourself with the concepts and the process. I think you can probably do that. Again, it's all online, it's all available to do. And it's just a series of screens where you fill out the applicant's information, you put the mark in, and you have to identify the goods and services that the trademark is going to be associated with. So, it does take a little bit of practice to kind of get used to that. I wouldn't say it's the most complicated process, but if it's not something you've encountered before and dealt with, then it probably can be a little overwhelming initially. Another question is there a pathway or method to protect IP, proprietary designs, technology, etc., in the international and global marketplace? And yeah, it's a good question. A little bit outside of my area of expertise, but certainly there are mechanisms in place depending on the type of intellectual property we're talking about. For instance, trademark, I believe it's called the Madrid Protocol, that allows you to, once you have a registration in a certain jurisdiction that is a party to these international agreements, that will allow you to streamline registering those marks in various other jurisdictions, as long as those jurisdictions are also a party to those agreements. And so if that's something that's important to you, it's definitely something to make your trademark counsel aware of, because there are certain time limits that you have to be aware of in order to take advantage of that. So same thing with patents. There's, I believe, a similar mechanism in place to get those patents kind of registered internationally. But again, that's a conversation that I would probably have to defer to our intellectual property counsel for further detail on that. So this IP assignment, that kind of touches on a little bit what we were talking about earlier in terms of what agreements do we have in place with employees or the co-founders themselves and our contractors and advisors and consultants, because these people are going to be developing things on behalf of the company and for the company's benefit. How do we make sure that the company owns that, and that this person doesn't create something and then walk away from the company and claim they own that? The IP assignment is definitely needs to be a part of whatever agreement you have in place with those people. And that basically says that anything that I develop, for the company while I'm providing services to the company are going to be owned by the company. And that's obviously important for when you have investors down the road. They want to make sure that they're, investing in a company that actually owns the work product and the development. So that is something that you need to keep in your due diligence and definitely have part of your agreements with all the people you do business with. All right, next slide, please. All right, discerning palettes only. Now, we touched a little bit about this earlier. In early stage companies, they frequently try to raise money from individuals rather than formal, private equity or venture funds. And those people are called angel investors, and those might be the people that you're kind of dealing with initially. One thing you need to keep in mind is that whenever you are selling something that did I cut out there, or do you still have me?
Still have you. You're breaking up a little bit. I think it's
All right,
okay now. And there's also a question here in the chat, Stephen.
Okay. Let me try something here before I do that. I was just getting a low resource suggested from Zoom here, so I wanted to close up a couple of windows. But the question is, does your firm work with assisting in contracts with co-manufacturers? Yes, definitely. We definitely have a lot of experience working with manufacturing, private label agreements, buyer agreements, licensing agreements, label agreements. So definitely that's something we have a lot of experience with, supply agreements as well. So it's something we deal with as needed. I was mentioning that when you sell equity or a convertible note or a safe to investor, essentially selling a security. And the default rule is that all securities need to be registered with the SEC. Okay, and that's a very expensive and time-consuming process. The nice thing is there are a lot of exemptions to the registration requirements. Now, the one that most early stage companies and startup companies take advantage of are the accredited investor exemptions. And that can usually mean, it's actually has a broad definition of a different types of, I'm being told I'm breaking up and to maybe turn my video off. Let's see. Can you hear me?
Try that.
Can you hear me?
Yes. I think it's
yes. Okay. Thank you. Okay. Sorry about that. So accredited investor has a broad definition, but the one that's going to be most applicable here is an accredited investor is someone who has an annual income of $200,000 or more, or $300,000 or more combined with their spouse, or they have a net worth of at least $1 million, not including their primary residence. So we're talking high net worth individuals. And, you can obviously understand that the reason for that is that the SEC wants to make sure that when companies sell equity, they're selling it to people who, have the ability to bear the risk of that investment and, theoretically should, have experience with investments or sophisticated enough to be able to know what they're purchasing. So when you're selling shares or doing fundraising, it's typically going to be with accredited investors. Now, investors, they don't get a card or a certificate or anything like that, but one of the documents that you have them sign when they're making the investment is a representation document that says they meet the criteria for being an accredited investor. It's not illegal per se to raise money from non-accredited investors, but the company's obligations do go up quite a bit in terms of providing detailed information about the company, audited financials. There's a lot of additional reporting and compliance that comes into play. So it's usually, doesn't make a lot of sense to try to do that just because of the work that would require in order to do that. And it creates some additional risk for the company if you're not in complete compliance. So if you're raising money from an angel investor, that really isn't an issue. All right, next slide, please. All right, so we're nearing the end of the presentation here, and we covered quite a few topics, and I appreciate you all's attention and patience while we kind of went into the nitty-gritty of some of these. But it all kind of comes down to, what are we collecting? What documents are we organizing so that when our company is ready to go out and get investors and raise money and take our business to the next level, what do we need to have to show these potential investors that we're ready to do that? And again, kind of running through the list of documents here, we have your organizational documents if you're an LLC or a corporation. We have your stock purchase agreements for the founder's purchase of the stock or other angel investors' purchase of stock. We have your stockholder or shareholders agreement, which is usually the agreement between the co-founders and any potential investors on kind of the transfer of any of those shares, the governance of the company, how decisions are made. We have a stock incentive plan, which we touched on earlier, is an allocation of shares set aside to incentivize service providers to the company, rather than compensating them with cash. They are incentivized by given options in the company. Those options come from a set aside in the incentive plan. We have founders agreements between the founders, again, kind of along the same lines as shareholders agreements on governance of the company. We have your vesting schedule. How are we going to be banking our equity over time? So that someone doesn't walk away with 50% of the company and never does another lick of work for the company. We want to prevent that from happening. We have the IP assignments. We want to make sure the company owns whatever is developed on behalf of the company. Patents and applications, trademarks and applications, copyrights and applications. All our IP is accounted for, represented. The company owns that, and we can show that it owns that. So do yourself a favor, make a due diligence folder, save all those. Investors will review those, and they consider all that when making an investment. And that's just part of the due diligence process. And you don't want to have to be scrambling to try to collect all that at that time, because that's a risk of looking unprepared and unprofessional. Next slide, please. All right, so bon appetit, just a final reminder. There's some things that you may be able to take care of yourself, but in general, it's general advice to not try to freelance on legal matters for your company. It's attorneys can be expensive, granted, but legal mistakes in the end can end up costing you more in the long run. So it always pays to have an attorney kind of help out at the outset and make sure that you're set up for success in the future. But thank you all for your time, and opening up the floor now for questions on anything we discussed or otherwise. All right, we have a question from Bindu. As a small company, you start out as an LLC. What do you commonly see companies switch to in the CPG space? I don't typically see necessarily a distinction between CPG companies or tech companies or other type of service companies. I think the considerations, a lot of times are typically the same. You start out as an LLC because it's easy to form, it's very flexible, it's a popular type of entity for early stage companies. But again, investors, when they're ready to come on board, may say, we appreciate what you've done thus far, but we're going to be more comfortable with investing in a C corporation and specifically a Delaware C corporation. So go ahead and convert. And so that's typically what we commonly see, LLCs converting to C corporations. And again, that's a straightforward process. You put together what's called a plan of conversion that says, my 20% membership interest in the LLC are going to convert to 2,000 shares in the corporation. And it's a straightforward process involving just filing some conversion certificates with the relevant jurisdictions. But it applies to CPG and other types of companies as well. How early in the company do you recommend in the SAFE? Well, I'd recommend it for, at the point the company is ready to take on financing, however that may be. If you have an investor who is comfortable making this investment based on where the company is at right now, and you have a business plan in place that they believe in and are confident in, then that's fine. And then again, the nice thing is there's not a maturity date on a safe. So you have the benefit of that time flexibility to, try to maximize the use of that investment and create value for the company, so that you put yourself in a good position for an equity raise in the future. So obviously the longer you can delay taking on investment is probably better for the company, because you're building value in the company and you're increasing the value in your stake in the company. And you're able then at that later stage to say, well, for the amount of money that the investor is putting in, you're going to get a smaller stake in the company because my company is very valuable. So, the longer you can delay that, the better. Converting from an LLC to a C corporation, how much would that typically cost time and money? So obviously, there's attorney's fees if you hire an attorney to do that, and filing fees that would be involved. So I would estimate probably about $1,000 in filing fees, because you do file a conversion certificate in the jurisdiction that you are converting from. So let's say you're a Texas LLC going to a Delaware C Corp, you're filing a certificate of conversion in Texas, letting Texas know what you're doing. That might be $500, $700. And then you're filing a conversion certificate and articles incorporation in Delaware. So that might be another $500, $750 in that jurisdiction. So again, $1,000 to $1,500 in filing fees. And then for the attorney, is if there's not a complicated capitalization structure with the company, meaning only a few owners there, and there's not going to be a lot of other kind of ancillary transactions happening at the same time. This is kind of a straight conversion, and that can usually be done for about the same, another $1,000, $1,500. So about $3,000 is what I would estimate for something like that.
You will get this recording and the presentation on it as well. How do we reach Stephen? We'll also provide you a list of resources in the chat so we can give you the contact info and whatnot.
I just dropped my my contact information there in the chat. Does anyone else have any other questions, comments? Well, I thank you all for your kind attention today. Sometimes legal, is not the most exciting topic, but hopefully you all learned a little something today, and give y'all some food for thought moving forward. And you have my contact information. If you need anything, please don't hesitate to reach out. And I definitely look forward to meeting you all in person at an upcoming event sometime soon.
At the very least, at the September presentations.
Yes, definitely.
Thank you so much, Stephen. We appreciate your time and all of the information, getting lots of comments here about how helpful that is. And I'm sure this is going to be one that we look back on later going, what is the legal ramifications of this and this? So you'll definitely be hearing from us, I'm sure. For all the MO fellows, I just want to make sure you have the contact, the login, same login for the Brew Crew tomorrow. Same bat channel, same time. If you have any questions, please reach out to me and make sure everybody has my stuff here while Katrina is gone. And here's my number as well. Great. And if you have any questions after the session that you can think of, shoot them to us, and we'll do our best to share them. If you have the question, if somebody else probably does too. So we'll do our best to share it with everybody and get some answers for you. And yeah, thank you so much, Stephen. Any last comments?
Oh, well, no, just thank you all for your time and attention. It's been a pleasure to be with you all this morning, and I'm available if anything kind of comes to mind as you proceed through the program. I wish you all the best of luck and success in the rest of the program, and looking forward to seeing you all soon.
And I had a couple questions about tomorrow, so I will resend the invite just to make sure everybody has it on your calendars, and we'll resend the further the next week's classes as well with more detail of who our speakers are and whatnot. Thank you. Okay, I'll stop the recording and let you all drop off as you need to.